All right, so this is Bradford v. State Supreme Court 285 Georgia 1 from 2009. An overt act is one commonly understood to be, quote, open, quote, manifest, or, quote, public, and that is citing Black's Law Dictionary. I think that's just the definition of, I don't know, it's a different Black's Law Dictionary than I have right now, but open, manifest, or public from Black's Law Dictionary, 1990. Mine's probably newer than that.
Yeah, the most recent one is...
Mine's not the most recent one. It's probably from law school, but...
All right. It's the best one.
It's the 7th edition, the one that I have in front of me right now.
I think we may have agreement that outward does the job. I think the fewer words that are used here, the better.
I think manifest can be confusing to a non-lawyer. So I'm okay with outward. Unless Max disagrees with me again.
I don't know what manifest means.
So outward, yeah, outward is good.
Outward. Okay. Means an outward act. Made in furtherance of a conspiracy. Okay. Thank you all for your help on that.
I don't know if we made it any better, Your Honor.
All right. Now back to the naturally and necessarily. Ms. Percival, do you remember what case that language came from? The under enterprise, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally and necessarily done to further the unlawful enterprise. Okay, we'll get back to y'all. Mr. Floyd, it's from the jury instructions from the APS case, which you touted to be the standard by which we should all be measured.
I think I did.
I think we're gonna.
Things evolved a bit since then.
I think we'll be leaving that in there.
All right.
Thank you, Ms. Percival.
My plan is to not die on that hill. On page 3, Your Honor, definition of racketeering activity, the first line. I don't think or soliciting someone else.
Yeah, that's why it's highlighted.
Commit.
So that was where the teal stuff got confusing. I didn't know whether the state wanted that in or out.
I think we can take it out.
So
What we were trying to do is simplify it by not having you instruct on things that aren't.
Well, I don't believe there's any allegation or any evidence of solicitation of someone else.
Yeah, I don't either. Okay, so that would then just read, means committing or attempting to commit any of these crimes in the list. All right. Under the list, I think the states had use of an item with an altered identification mark. Do we have evidence of that?
Yes, Your Honor. It was the Trontavious Stevens had a firearm with a scratched off serial number.
Okay.
That I think that evidence came in through an officer testifying about it.
I thought so. I just wanted to circle back on that one. And then all of your other teal things, again, I didn't know whether that meant
I
take these out, leave these in.
I apologize, Your Honor, for the teal confusion, but my intent was to, well,
let me ask you this. If you look at the list as it exists in this draft, does that cover?
It does, Your Honor, and I actually, the burglary,
Right.
we do not need that. There was an allegation of a burglary on an overt act that we did not present evidence
All
of.
right, we'll take that one out.
What about use of an item with an altered identification?
Yeah, we just talked about that one.
Okay, I'm sorry.
And Mr. Atkins is right, there was some evidence of that introduced.
Okay.
The possession or the use of?
The reason we put, let me explain that changer. Okay, sorry. Is that some of the drug-related offenses are broader than mere possession or use. And so we put possession or use in there because that's possession and possession of with intent to distribute. That's what's charged.
Where are we talking about?
We are in the list of crimes, the last two.
Okay. Possession of marijuana with intent to distribute and possession of marijuana?
Right.
Okay.
And I think we meant to make this modification with related to controlled substances. It may not have gotten in there. But the same thing, possession of controlled substances, possession of controlled substances with intent to distribute.
Okay, so right now it's violation of the Georgia Controlled Substances Act. Do we want to,
We can,
Article 2, and I assume that both codeine and cocaine are within Article 2 of, okay.
schedule, cocaine's a Schedule 2, codeine's a Schedule 2 or 3, by memory. Yeah.
So then it would be what? Possession of codeine with intent to distribute is what was charged, right?
Yes, I believe so. I mean, the language about Article 2, that comes from the actual language of the statute.
Right.
That's written for lawyers, that's not.
Right, no, I agree, I just,
Yeah.
okay, possession of codeine with intent to distribute, possession of marijuana with intent to distribute,
And then we have
possession of cocaine, and possession of marijuana. Okay. And then I still need, we're going to have the definition of murder anyway, and of the, we won't have the, I still need the definitions for all of these, the pattern language definitions.
Mr. Atkins, didn't you submit that?
Yes, Your Honor. Yes,
Okay, all right.
I'm not the Your Honor.
Okay, moving on to pattern of racketeering activity.
If you know, one
Yep.
other thing.
Sorry.
Based on your ruling, possession of marijuana could come out, your directed verdict argument, verdict ruling.
Nope.
No, because there's code.
It's a,
It's still over, sorry, my mistake.
I'm sure the
I agree
defense
with
would be
Mr.
happy
Floyd.
to have it out.
I agree
but-
with Mr. Floyd, they can come out.
Yep. I think he misspoke on that.
Do the current charges on the table have this second paragraph with about the threats? That
Where are you?
I'm looking at.
Is it under racketeering activity or something else?
Well, I mean, right, under we have racketeering activity,
Uh-huh.
and we define it, and then we have a second racketeering activity.
Right.
Also means any act or
Right.
threat.
Okay, I don't know. Do we have a threat that involves murder, robbery, theft, receiving stolen property, obstruction of justice, or dealing in narcotic or dangerous drugs?
We're going to bring them homicide. Yes, for the caption of one of the photos. Yes, we do have, we have threats and we have acts.
Okay,
So, I mean, the any act or threat involving language comes directly out of the statute.
Okay, but we don't have a threat of robbery, theft. I don't even know what a threat of dealing in narcotics or dangerous drugs would be.
by God, I'm going to deal in narcotics.
We don't have a threat of obstruction of the officer. I don't know what a threat of receiving stolen property would be. So why don't we just say, and take what I would suggest, we just take that threat paragraph out, and we could just put murder or threat of murder.
Well, and then you would have what? Any act involving for the
Any
remaining
act that involves murder, threat of murder, robbery, theft, et cetera, et cetera.
I think that could do it, yes.
Okay. Thank you.
Great with that, thank you.
Okay. I'm actually changing it online. What else? So that takes us to pattern of racketeering activity, although we definitely need the definition of the underlying crimes somewhere.
Your Honor, going back just a second.
Okay.
On the reference to controlled substances on page 3, the two specific drugs would be cocaine and codeine, possession with intent to distribute.
Okay, so what I've done is just like we listed the specific other things, I've got possession of codeine with intent to distribute, possession of marijuana with intent to distribute, possession of cocaine, possession of marijuana. Does that work? Okay.
All right, thank you. All right, we did not, I don't think we tealed up page 4, which would take us to page 5.
All right, are there any issues for the defense on pattern of racketeering activity?
Yes.
Okay. And I've even got an issue on what I list as my element number 3. When it's only a conspiracy, there don't have to have been racketeering acts achieved. There might be, but there don't have to be. And so how do we deal with they've got to be within 4 years of each other?
I don't think it's relevant here because the question is the contemplated objective, not the actual way it turned out, because that would be a substantive charge. I don't think there aren't any that are separated by more than 4 years.
Well, I mean, y'all were just arguing we've got the murder of Donovan Thomas in 2015, and then we have the murder of Mr. Drinks in 2022, right, which is more than 4 years. And so assume that's all that they find is interrelated. Then what?
Those would be the acts that actually occurred, okay? And in a substantive case, that would be an issue, right? But this is where we get into this whole problem of exactly what was everybody contemplating exactly every moment in time in a case like RICO that tends to unfold over time. And so, Shamel, specifically, let's kill Shamel Drinks might not have been in everybody's mind 4 years before. At some point, it came into.
But if they contemplated
Killing opponents.
let's kill not just the leader, but the leader and everybody else we see,
Kill the cat and all the kittens as the.
then does it even matter? Does the 4 years not matter then?
4 years does not matter in that circumstance. And there's certainly no Georgia case that says it does.
Well, are there any Georgia cases that deal with conspiracy assertions and not substantive that also talk about this?
Provision?
Yes. To me, this is the toughest issue there is in terms of figuring out what the actual law to charge is.
I understand the challenge, Your Honor, but again, the one thing that when you look at the cases that address conspiracy is that while there are aspects of conspiracy and substantive charges that are similar and maybe even overlapping in some respects, conspiracy is different.
Yes.
And so what this is basically importing the what ultimately happened test in here. I'll go back to the hypothetical. and I'll try and.
Well, I mean, I understand your hypotheticals. What I'm going from is the statute, which is what the law actually is, unless, further developed by case law.
I mean, the question is whether the conspiracy contemplates a pattern of racketeering activity. And if that pattern could take place within 4 years, I think that would be sufficient.
Right.
And we can't say that everything that actually happened had to fit that.
But how do we explain that
Changes it out of it. It's not a conspiracy case anymore.
to the jury?
Now,
I mean, I don't think this needs to be mentioned to the jury, but if the court believes it does, the way to do it would be, I think, to say that they considered engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of, and not make this a separate thing at the end.
Well, so, Your Honor, on page 4 of, I think it's on both your drafts, you have an instruction, and I took liberty to propose some changes, so it might not be exactly how it is in your draft, but it says the state must prove, I added beyond a reasonable doubt.
Yeah.
that defendant-
I'm telling them that all of this is beyond a reasonable doubt. None of the pattern charges that have been changed say that every time, so.
Okay. And it says that defendant, and I took the liberty to say knowingly and willfully, agreed to join a conspiracy with the knowledge and
Okay,
intent.
are we back up at, I'm trying to figure out where I should go.
Mr. Short has jumped down to below the line of asterisks where it says
Okay.
4 count 1.
Okay.
But I think that this charge may be what we're
Okay,
essentially
go
talking
ahead.
about.
I
The
just
state
wanted
must
to know
prove
where to.
the defendant,
Uh-huh.
I added knowingly and willfully,
Okay.
agreed to join
Yeah, that
a
needs to be-
conspiracy.
With
with
the knowledge and
intent
intent is
that-
knowing and willingly, I think.
Okay. Yes, Your Honor, that one or more conspirators would commit at least 2 interrelated acts of racketeering activity, and then I think we're saying within 4 years of each other. And it seems like that charge would go to under where we're just previously talking.
Okay.
So we'd move that up. It seems to me.
And, Your Honor, I was not clear from this whether the section that begins on page 4 and is under the asterisks, whether this is something you were intending to speak to the jury about in connection with a verdict form, or whether this is part of the instruction.
Yeah, I don't know. I mean, it's part of the instruction. I think it needs to get said. Whether it gets said here or whether it gets said when I get to the verdict form, I hadn't decided yet. I just think this stuff needs to get said. So I don't know the answer.
Okay, here's my concern is
Yes.
that to the extent you're restating elements that
Yeah.
have been stated before, they're being restated in different language.
Right.
And that can be a source of confusion. I mean, the court, the way I was interpreting what the court did at the beginning of these instructions is you tried to make these as short and succinct and simple as you could, consistent with the language of the statute, and I understand that. But here we're kind of restating the same premise, but with different words. I don't know which set of words the jury's going to follow. That's my concern.
I mean, as long as they're not inconsistent words, it doesn't matter. If they just further flesh something out, that's fine. So if you think they're inconsistent, point that out to me when we get there, preferably. But I don't think more words is worse. Frankly, most of this language is from some version of what the state wanted at some point. But I mean, I was kind of thinking it would be when we're talking about the verdict form, but yeah, I definitely don't want to be inconsistent. That would be bad and confusing. Don't want to confuse, want to clarify. Okay, so within 4 years of each other. So back to pattern of racketeering activity. I'm back up at page 3,
Okay.
defining pattern of racketeering activity. Okay, but see, hang on. So we're defining pattern of racketeering activity. You need the concept that they have to be within 4 years of each other. And then they have to, they're not being found guilty of engaging in a pattern of racketeering activity if what they're supposed to be determining is, did they conspire to engage in a pattern of racketeering activity? But the jury still needs to understand what a pattern of racketeering activity is. So how about pattern of racketeering activity means 1, engaging in at least 2 acts of racketeering activity, 2, within 4 years of each other, 3, in furtherance of 1 or more interrelated incident schemes or transactions, and then explain what interrelated is.
I didn't mean to speak over you. I think that is easier.
Okay.
It flows better.
Yeah.
It actually flows better than
It does.
statutory language.
Yeah. Okay. All right. I think that's what we'll do then. So where does anybody have?
And this is not in the teal edits, but we're doing this quickly, and sometimes as I'm reading it through, I recognize this is not the biggest deal in the world, but I think interrelated might be easier if you said interrelated here means acts that have, and then you pick up that same or similar, because interrelated modifies acts.
Okay. Yeah, that is definitely clearer.
With regard to criminal objectives,
Hang on.
sorry,
Interrelated here means acts that have
yes.
the same or similar blah, 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 or that are otherwise interrelated. Is that what you're proposing?
It is.
Okay, I think that works. All right, next.
Here, as far as criminal objectives, you pointed out that, as expressed in the indictment, there were some things that were not illegal, wouldn't automatically be illegal in some of the 5 categories that we listed, and you taken 3 of them here.
Yeah.
We do not object to that.
Okay.
And I think this encompasses also everything that was illegal in the other 2 categories, and therefore it's easier for them to remember 3 than it is to remember 5.
Okay.
Does the court plan to give them a copy of the instructions?
Oh, yeah. I always do, even in a one-day burglary case. Yeah. Not that we ever try those, but yes.
Yes. Okay.
There's no reason it has to be a test of memory. I'm not, however, going to tell them that until after I give them the instructions because I want them to pay attention. Okay. All right. So now down to the kind of paragraphy language. My thought was that that would come not within these instructions, but at the very end when we get to the verdict form. But we still need to kind of walk through them and make sure that there's not anything that's incorrect or inconsistent that I'm saying. And Mr. Shart, you had mentioned, does the first one need to say, knowingly and willfully? And maybe I was thinking, and with the knowledge and intent would be the same, but it probably is safer to just say knowingly and willfully. Okay.
Is that additionally or in lieu of?
Well,
I'm sorry, what's the proposed revision?
for count one, the state must prove that the defendant knowingly and willfully agreed to join a conspiracy. And then I think it would maybe just say with the intent that one or more conspirators, himself and or a co-conspirator, would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to either get or keep money or other property or participate in the enterprise.
Okay, I don't object to that language, Your Honor. Thank you.
My only concern here, Your Honor, is that I don't know that we need a second statement of intent here. Knowingly agree to join a conspiracy.
I mean, if I don't say what the conspiracy is down here, I mean, we could join a conspiracy to, you know,
I'm sorry.
do all sorts of things that wouldn't be RICO.
I understand. I think you're expecting me to say something I wasn't about to say.
Okay, sorry.
No, it's okay. It's all right. Agree to join a conspiracy, I think understanding.
Oh, instead of with the intent?
Yes.
Yeah, understanding is much better.
Or maybe
Thank
with
you.
the understanding that. Either way. That way we're not getting two intent standards in the same.
Understanding works.
Right. With that change, I don't think there's anything incorrect in that, and I don't think it's really inconsistent with what you said before.
Okay.
It's kind of a restatement. My concern is that we're getting the following paragraphs get into, I think, them determining, walking through the indictment and determining, are we unanimous on this one, are you unanimous on this one, etc., as opposed to what we were discussing yesterday, which is just telling them, you have to be unanimous that there was an overt act, you have to be unanimous on which one it was. And you'll be telling them that it has to have come after a certain date. So that covers everything. This is frankly part of my worry here, is that we get a jury who goes in with a very, very long form, they get tired, they go through, they check off a few, and then they say, well, that's good enough, she said we only needed one. And this only works if they go through the entire thing.
I mean, I'm not listing all of them on the verdict form, if that's what you mean.
Then I misunderstood. I was afraid that that's what it
So what I was thinking about doing was saying, like, you know, I don't know yet, but defendant X did not join whatever this conspiracy is. If it's did not, that's the end of count one. If it's did, then potentially these are the interrelated types or acts of racketeering activity, or this is the pattern of racketeering activity, and have them listed.
But then now we've turned it into a substantive case, not a conspiracy case. That's my concern.
No, but there-
This is the pattern that they agreed to. You must then determine which interrelated types or acts of racketeering activity the defendant agreed would be committed.
Well, I don't.
They agreed that they would murder everybody, or whatever they might come up with.
I see. I think I understand what you're is looking at. Problem is types or acts. I mean, are you contemplating that they basically have a menu and they check it off.
No.
And the menu is acts of violence, narcotics, property crimes. I mean, that.
I mean, I was gonna get input from y'all. I don't know.
Well, that might work. I mean, my concern when I read this was I thought we were back to the point where we were looking at a list that just tracked every overt act in the indictment, and I can see a lot of reasons why that could cause problems.
So it could either be, you must unanimously determine which interrelated types or acts, that one's still up for debate, of racketeering activity the defendant agreed would be committed, and then have them listed, or that interrelated types of racketeering activity would the defendant.
I think all they have to decide is that they contemplated committing interrelated acts of racketeering activity.
Well, they agreed to, not they contemplated it. You could contemplate it and reject it.
Fair enough. Okay. But that's really the question before the jury is, did the agreement contemplate what would ultimately have become a substantive violation? I'm very concerned about using the word acts because you can see how they can get all hung up on that. And that's not really what the conspiracy law requires the jury to determine is the specific acts. That's what we talked about yesterday. The federal case I cited to you, they all say they don't have to determine which specific acts were contemplated, only the types.
But even those federal cases say that the jury has to be unanimous on the types of acts that were committed. You'd agree with that, correct?
Whatever the jury's deciding, they have to be unanimous. I agree with that.
And
All right,
unanimous on the types of acts.
Don't talk to each other. Got to
I'm
talk
sorry.
through me. That's just how it works in court. You know that. I know you didn't mean anything by it, but
I
it
always
sometimes
enjoy discussions.
devolves. I don't think it would with this particular crowd we have right now, but
Anyway, Your Honor,
yes.
I believe that the federal cases that Mr. Floyd cites would require the jury to be unanimous
Yeah.
in the types of racketeering activity, and I think it would be necessary for them to indicate which are the types on their verdict form.
I don't think it's required.
Well,
just trying to
shall we
figure
say
out-
helpful? I'm trying to also contemplate if there is, as Mr. Steele might say, God forbid, a guilty verdict in this case, and an appellate court is reviewing, I think without some tiny level of, I even hesitate to call this detail because it's so high level, but some guidance on the basis for the jury's verdict that it would be difficult to review. And also we would want to ensure that they are unanimous on the type. So if they indicate the type, that would ensure that.
But here's my issue with type. I mean, so let's say they don't decide, or the jury doesn't think, oh, they decided they would murder every op. Let's say they think they decided, we're just going to hassle Lucci in any way possible. So we're going to steal things from Lucci. We're going to stab Lucci's mama. We're going to do X, Y, and Z. Those are different types of racketeering activity with the same victim. So it doesn't have to be the same type. And that's correct. So that's the wrong word to say.
And it's the one that crept into the case law, but I think
Yeah,
observation is correct.
it's wrong.
But-
And I'm sorry, y'all, I'm kind of like thinking through this as we do this, because I've never done a RICO case before as a judge.
And I've never done one that didn't have a new issue pop up that I never thought
Right.
of before.
But,
But as Mr. Floyd says, that is the language, as unfortunate as it may be.
well, I'm not going
in
to, I
the
don't care
case
if
law.
language is in a case. If it's wrong as law, I'm not going to use it.
So, Your Honor, to follow up on the point you just made,
It's-
in this case,
Yeah.
what we are really talking about with this enterprise, with this criminal street gang, is an open-ended conspiracy, because they're going to do what they decide to do. And once you're in, you're basically agreeing that you're going to do what that enterprise is going to do. As long as these are things that such an organization might accomplish when you sign up for it. And this is what, when you look at the older U.S. Supreme Court cases, the one that sort of states the bedrock principles, like Pinkerton, for example, basically says, you know, if you sign up in a criminal endeavor, you're on the hook for whatever follows from that. The solution to that is not to sign up for it, is not to become joined into it. And in a gang like this, an organization like this, sort of one of the fundamental tenets is acts of violence and threats of violence against those you perceive as your opposition or competition. You know, that's the path. You know, the real question is, are you agreeing to join in an organization that does those things?
But it's
And that you or somebody in that organization would do them.
Well, right, yes, but that's my point.
Well, I mean, that's the rub.
That's within the contemplation. I mean, when you're joining up, those things have already happened. You already know this is what this organization does. It's not like you joined the Boy Scouts and you found out that they're engaged in acts of terrorism. It's like joining a terrorist organization and finding out they're engaged in acts of terrorism. But I mean, I think this language that we have here is getting at the point, which is, do they contemplate interrelated acts of racketeering activity will occur?
and we do.
And I guess we've already said it up above. If we're not going to say what was it, then we've said the state must prove the defendant knowingly and willfully agreed to join a conspiracy, understanding that one of them would commit at least 2 interrelated acts of racketeering activity within 4 years of each other to do one of these 2 purposes.
And in Georgia law, with the statutory definition, we pick up the same types in there. I mean, it's kind of baked into the definition that you've already got in the instructions.
But, you know, we're in a situation where, and I understand it, where the state does not want the jury to go through and say, we find this act, we find this act, we find this act. And that's the same thing that happened in these federal cases where there was an argument you shouldn't have to find specific acts. And I think that's why the federal courts have gone to, okay, fine, you don't want us to look at these, to have the jury identify specific acts, but they do need to identify, I guess they went one level up to types of acts that occurred.
Well,
But was that a conspiracy case? I mean, as long as I'm saying you have to be, I'm sorry, that you have to be unanimous that they proved all these things.
Go ahead,
I
Mr.
don't mean to
Floyd.
interrupt you. To be clear, the cases that I was talking about yesterday, those aren't verdict form cases. That's where the request was that the jury be asked to fill out a form that went through every single one of them. And they said no, and the jury was instructed on types, not that the jury filled out a form on types. We don't want to it's not I don't want us to back into giving them an essay question. That's not what we ask juries to do. Juries say yes, no. And if we kind of open it up for them to express themselves, I think we're asking for trouble. There's a good reason why.
And again, I'm not requesting a essay from the jury. I just think that having them identify what is the type of activity that they have found, or, I mean, it's not my preferred outcome, but some form of check the box, as the state may have indicated, perhaps, just some guidance more than yes or no. And I appreciate that that's what the state would prefer.
Your Honor, I have an idea. We're all thinking out loud here a little bit. if it is contemplated the commission of two or more related acts of racketeering activity in furtherance of one of the criminal objectives of the conspiracy. Because that would actually tie in to something concrete that you're already doing.
Say that again.
Agreed to join a conspiracy, understanding that one or more conspirators, himself and or a co-conspirator, would commit at least two interrelated acts of racketeering activity to achieve one or more of the criminal objectives of the conspiracy. The reason I say that is you're telling them what those objectives are, and those objectives encompass the substantive violation.
And is that a recommendation regarding the second to last paragraph on page 4?
Yes.
Could I ask what that proposed language is again?
Memory test.
To achieve
Well, that's-
one or more of the criminal objectives of the conspiracy. Right?
Yes.
But where are you saying to put that?
Where you have 1 and 2,
Yeah.
instead of sub 1 and 2, in either, you just say acts, racketeering activity to achieve one or more of the objectives of the criminal conspiracy.
Okay, so
And the reason I say that here is because those objectives contemplate the violations of A and B.
but how do I know? Does it even matter? Do I need to know which one they return?
Done because of Cotton 2.
Well, I don't know what that shorthand force or what does Cotman 2 say?
Cotton 2 said it is sufficient to prove either or both of the A or
But I don't need to know.
conspiracy to violate either or both of A or B.
Okay, well, I know that, but I don't need to know which one or ones they found.
No, you don't. And that was exactly the question in Cotton. And
I don't think it should be the goal of the court to make the jury's decision as opaque as possible.
Well, I'm obviously not trying to do that.
I didn't want to imply that the court was.
see, that leaves one person.
Well, I'm not allowed to directly address you, Mr. Floyd. Which,
So, can I,
Yeah.
so we were talking about, back up to that paragraph, the second to last one. And Mr. Floyd, if you could just help me follow your train of thought, does that affect what you're proposing in this second to last paragraph? Does that affect the last paragraph on that page?
I think it removes the need for the second paragraph.
See, that's what I was concerned about, because the second paragraph still has the unanimously and the interrelated types of acts. So I understand what that Mr. Floyd is trying to incorporate into the second to last paragraph, but it's still leaving certain aspects of the last paragraph out.
Well, I understand.
is the state suggesting removing the last paragraph?
That's what I just said. I think it obviates the need for it. And remember that as we're discussing this, Your Honor, this all is coming after you have instructed the jury on overt acts. They understand what they have to find.
But they do have to unanimously find which types of interrelated racketeering activity occurred. That must be unanimous.
Well, they have to unanimously find that conspiracy, and then
Yeah.
also determine what.
Right.
And, Your Honor.
All right, I'm satisfied that they don't have to list out what pattern of racketeering activity they think anybody may have conspired to commit. As long as they unanimously agree that a defendant conspired to commit a pattern of interrelated racketeering activity. Is there any case law that they have to list it out if it's a conspiracy case and not substantive?
First, I'll divide my answer into two parts. Part one, Georgia, no. Part two, I'm not aware of any other jurisdiction that requires it, but certainly not in Georgia.
But, Your Honor, this is my
Yeah.
understanding. It's not just that they have to unanimously determine that, say, Mr. Stillwell joined a conspiracy, and with the intent of a pattern of racketeering activity, they have to unanimously agree on,
What it
right, which,
is.
right.
Mm-hmm.
Like if some of them say, oh, he was joined for
Right.
theft, and the other,
Right, okay.
And Your Honor, I think my suggestion contemplates this because by referring back to the criminal objectives, we stated what those are. They only have to find that it contemplated two or more acts in furtherance of one of those objectives, and these objectives refer to specific types of criminal conduct.
Objectives and pattern of racketeering activity are not the same element.
I understand, but each of these says through acts of racketeering activity and then lists crimes. It doesn't just stop at objective. It says you're going to achieve this objective by committing these crimes.
So you're saying that if they find any of those, that any of it was done to further a criminal objective, that even if it was, let's take criminal objective 1, a count of murder and a act of murder and an act of a threat of violence were what was contemplated, that would necessarily be interrelated because they would have had to determine that it was in furtherance of criminal objective 1, which is preserving, enhancing, protecting, blah, 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 which is a same or similar intent or result.
With the exception of the blah, blah, blah part, you said it better than I did.
Okay.
Yeah. I mean, I think it's already captured there.
Yeah. Thoughts?
we've been moving around a lot. Could I just hear the final proposal, or what we think is the final proposal?
I don't have one yet. Mr. Floyd's is that in that first paragraph, that instead of saying to either 1 or 2, that it would just say within 4 years of each other to achieve a criminal objective of the conspiracy.
I understand that.
I haven't gotten past that part yet, too. I'm trying to figure out, how do I am at the point where, okay, that paragraph says everybody has to agree that they agreed to commit interrelated racketeering, a pattern of racketeering activity. But if they have to unanimously agree what pattern of racketeering activity was contemplated, then I need to at least tell them that.
Is there any disagreement among the parties that they do have to unanimously agree?
I don't think so. Everybody agrees about that, right?
Unanimously agree with what?
About what pattern of racketeering activity they agreed would be committed.
And state's view of this is that if it is, they had to agree to commit this act, that act, that act. I think we've passed that. I think
That's not what they're asking about.
all right. And so when we
Hang on.
Sorry.
Does the state agree that there needs to be a unanimous determination as to what pattern of activity, racketeering activity, was contemplated as being carried out, whether it ever got carried out or not?
I don't believe the statute requires that.
I
And if I can just finish.
yeah, I'm sorry. The
conspiracy has to contemplate the pattern.
Yes.
Yes, right. Does the conspiracy have to contemplate specific crimes?
I'm sorry, that's not what I mean.
I understand. I'm
Okay.
I'm trying to walk through the hierarchy. Does the conspiracy have to contemplate specific categories of crimes? No. All it has to do is contemplate that the crimes will be related to each other.
Right.
Because that's what would form a pattern.
Okay.
But do they have to be unanimous in their determination of whether they tell us what it was or not, of what that pattern was? I'm sorry I mean, this is probably really painful for everybody,
No.
but
And I don't
we
mean
need
to
to get it
interrupt.
right.
I don't mean to interrupt anyone. I'm just looking at a case from the 10th Circuit, U.S. v. Randall. I'll give you the site in just a moment, but I'm sure the state knows it. And I'm reading where they're trying to decide what circuits to align with.
Yeah.
And they state further, we now join the circuits discussed above in concluding that for a charge of RICO conspiracy, and this is as the state says, a jury need only be unanimous. Well, they don't say this. A jury need only be unanimous as to the types of predicate racketeering acts that the defendant agreed to commit, not to the specific predicate acts themselves. And that's where I thought that we were in agreement with the state, that there needs to be unanimity. And I know you don't like the word types, and that's their language, not mine, Your Honor. But there needs to be unanimity, and let's call it the pattern of the predicate racketeering activity. And that's the 10th Circuit, and I believe they're agreeing with a number of other circuits.
Okay, so how about if we just say, would this work? Is this correct and sufficient? You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed.
That's acceptable to Mr. Kendrick.
Could you say one more?
Sure. You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be permitted.
Committed.
What did I say?
Permitted.
Committed, sorry.
Your Honor, I do have a problem with that.
Okay.
Because I think the jury is going to read that as they had to agree to commit specific acts. I know that's not what you're intending to instruct them, but I'm afraid that's what they're going to hear, and that's what the argument we're going to get.
Then we
which
can
would be
say,
contrary to the law.
you do not have to be unanimous about specific acts, ... only, I mean, let's just nip
Unanimous.
it in the bud. Just tell them.
That would be great,
Only unanimous in the pattern.
that there would be a pattern.
Oh, we're so close.
And what the pattern is, really.
Right,
A specific matter.
yeah.
Well, the word specific just is another way to.
We
back
won't,
into
we
the
won't
same
say
problem.
specific, unanimous. I mean, I just said it, so I'm not going to say it again. You do not have to be unanimous about specific acts, as to specific acts, what?
You do not need to be unanimous as to any individual acts?
Individual, I worry about, because most people
As
think
to.
of individual, they think of a person.
Single act.
I like specific.
You do not need to be unanimous as to specific acts.
I think that's accurate.
Can you read it back as a whole,
Sure.
Your Honor?
You must be unanimous in your determination as to the pattern of racketeering activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts.
Are you going to say that after, if you unanimously determine that the defendant joined such a conspiracy, and then say what you said? I'm just going by the last paragraph of page 4.
I mean, yes, I don't even know where that language went, but what did I say? After the first paragraph, then what did I say? If you,
You mean, what did you previously have in
Yes.
this document? The document originally read, the one sent to us at lunch after that paragraph. If you unanimously determine that defendant joined a such conspiracy, comma, you must then determine which interrelated types, with the S in parenthesis, or acts of racketeering activity the defendant agreed would be
okay,
committed.
no, I don't think I'm going to say that anymore. I think because I am saying the state has to prove they, agreed to join a conspiracy, understanding that somebody was going to commit at least 2 interrelated acts of racketeering activity, and within 4 years of each other, to either get or keep money or participate in the enterprise, or to achieve a criminal objective of the conspiracy. I think maybe then, right there, just put in parentheticals, quote, pattern of racketeering activity.
Sorry. Did we lose your...
But then there was the language.
I know, I hadn't gotten to it yet. I'm sorry. Sorry. I think I would then just say you must be unanimous in your determination as to the pattern of activity the defendant agreed would be committed. You do not have to be unanimous as to specific acts. I don't know.
That's acceptable to Mr. Kendrick.
Okay.
Could we get a brief break at this
point.
Yes.
Your Honor, obviously I'd like to look at the
I
final
know,
words,
and
but
I'm
I
still
think,
thinking.
in principle, I think you've got it.
All right. Yeah, let's take a quick break.
Thank you.
All right, are we enough of us back that we can dive back in? I think I may have come up with a way to say this. So we had talked about in that kind of first paragraph, whether to say that either, money or property or participate, or instead to say to further a criminal objective. Was everybody in agreement about that, or no?
Are we on page 4 you're on?
Yes.
Is there any way possible to throw that up on the monitor?
Yes, I could screen share. I could join Zoom and screen share.
That would be very good.
What a great idea. Okay.
Thank you.
Bless you. I think I'm in Zoom already.
Thank you, Ms.
I'm not usually the one sharing, so. A moment, I've got it. I just have got a lot of things open, so I think it's this one. Is that the right one? Okay.
Oh, that's very helpful. Thank you.
We should have maybe been doing that the whole time. All right, so one thing I've thought about is just kind of lead in, hey, y'all, your verdict as to every count needs to be unanimous. That means you need to be unanimous in your determination that the state has proven every element of that count beyond a reasonable doubt. For count 1, here's what the state has to prove. And I've put all of it in there. And I don't know whether we want to say to achieve a criminal objective or the one or the other. We can decide. But I'm going to say all of it. They have to prove all of this, and then they also have to prove, an overt act. To be unanimous on this count, you must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. You do not have to be unanimous as to specific acts. You must also be unanimous as to any overt act or acts committed to further a criminal objective of the conspiracy. And then whether we want, again, the reminder that it has to be after May 10th, whatever. And then as long as they're unanimous on an overt act, do they have to list the overt act? Or do I just, it's kind of the same question again.
State's positions do not. They do need to be unanimous. There was one, and which one it was, but they don't have to list it. They only have to be unanimous as to one.
Your Honor,
Yes.
for the record, I am objecting to that you do not have to be unanimous as to specific acts.
Okay.
However, having said that, if Your Honor is going to include that, to me, the last sentence that Mr. Floyd is objecting to doesn't make a lot of sense, because we're telling them they don't have to be unanimous, and then we're telling them you should note on the verdict form.
That's what I'm asking. Do they still have to?
Right. If we're going to keep in that that you do not have to be unanimous as specific acts,
It's confusing
as a juror, it wouldn't make much
to
sense.
then say you have to unanimous about an overt act.
Those are different acts. One is
I know, but are they going to know the difference? Acts of racketeering activity? Maybe that's the way to clear that up.
Okay.
Would that work better?
I think it would.
Okay.
And then I understand the state does not want the overt act on the verdict form. The defense would want or at least Mr. Kendrick would want that on the verdict form.
I would.
Which one it is?
The one that says you should note on your verdict form any overt acts in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. I would like to see that on the verdict form just to ensure that they did pick one within the proper time frame.
Okay.
And I'm not sure how council contemplate that this would actually happen. Would they list a number or
They'd write out, I don't know. I mean, I guess if it was an act in the listed out, they could just list the overt act number.
And I think, all right, this is why I'm asking, Your Honor, because they could also find an overt act that isn't listed out.
Well, then
Then
we'll
they
give
would-
them a little blank for
Yeah.
that.
I mean, I'm serious, like, literally
So am
to
I.
say, and, you know, you can list them by number, or you can list an act, anything else that you determine is an overt act, and they can go ahead and do that. I'm trying to think of physically how this happens without them, and I'm not, to be clear, I'm not saying the state doesn't object to that. I'm just trying to figure out what it is we're talking about before I address it.
How about that?
And Your Honor, if you could scroll up toward that long paragraph in
that
the
what
middle
that
of page
means?
4, there where it says for count 1. I think that's as concise as you can possibly make it, but I'm wondering, given that it's such a complicated paragraph, if it might benefit just from a formatting perspective if you broke it up the same way you did on page 1, where the different
Okay.
elements are on different lines.
For one thing, we need to decide, is it going to be, are we going to say this? Or are we going to say, well, that did not help at all. Which of those two things are we going to say? There.
I'm just studying for a moment.
So the orange is what Mr. Floyd had proposed. The blue is what I had originally. And we could have the i.e. a pattern of racketeering activity. That actually doesn't go there. That goes up there. Oh, no, it doesn't, because it has to be to achieve a criminal objective of the conspiracy.
I agree with that. I think the get or keep money or other property and participating enterprise is wrapped up in the statement of the criminal objectives which you've given them before.
Yeah, I know you think that.
Yeah.
So thank you. What does the defense think? And actually, Mr. Floyd, do you think that this survives appellate review as giving them the correct instruction?
Your Honor, I may be right, I may be wrong, but that question is forefront in my mind in everything I'm saying.
Okay.
Yeah. part of that is the appellate analysis, which is and this is why I've been referencing where you've said things in other places, you know better than I do, the jury instructions are read as a whole. And
I
think
know.
that encompass, given what these instructions have elsewhere, that gives me a good deal of comfort.
Your Honor,
Mm-hmm.
my preference is more for the original language with the caveat that might actually go against me is that I'm just not entirely clear what participate in the enterprise means.
Yeah, me either, but that's the way the statute's written.
Um,
I mean, honestly, I think it's, Mr. Floyd's might be more elegant, but the original tracks the statute, and we're less likely to commit error by tracking the language of the statute. Because if you go way up above to what the elements are, one of the elements for Part B is participate in the enterprise through a pattern of racketeering activity.
Right. Obviously, I can't challenge that, Your Honor. I was looking at in the language that I was suggesting, I was looking at number 7, where you list the elements, which references the criminal objective. So, circling back to that, I'm trying to be consistent in the language.
I mean, the other way we could say it would be, to join a conspiracy understanding that, no, it's just too awkward. I'm trying to flip like the order of them, that they would get or keep money or participate in the enterprise through, but I'm not going to do it that way. All right, it's just going to stay like that.
and then drop a comma after the 2017.
Yeah, you know, we're just going to have to agree to disagree on that, because I'm sorry, but I don't like to offset the year with 2 commas. Sorry.
Do you use an Oxford comma?
Oh, absolutely.
Okay, well, we can agree on that.
Okay, yeah. All right. And so then they're being told they have to be unanimous about the pattern of racketeering activity, but not specific acts of racketeering activity. They need to be unanimous that at least one overt act was committed in that time frame. And then they're going to list on the verdict form whatever acts they unanimously find. And then probably when we get to the verdict form, which we need to do soon, it's going to be, you can list them out by act number or write out what you find.
I understand, Your Honor. For the record, we do object to that last sentence. I don't think it's necessary. I understand that you disagree with me. And I'm just quoting that.
I don't know if it's necessary, but it's not error to do it. Is it? Okay.
That language itself, I'm not certain that it's error, Your Honor. The question is really, this is one of those devil in the details things, which is going to be exactly what that verdict form says when you embody that language.
Well, I've invited people to submit proposed verdict forms. So now that we know what the charge is going to be, I would continue to welcome that.
I understand, and we will modify our proposed verdict form because now we have a better idea of what the charge is going to be. Thank you.
And I'm sorry, it's just not an easy thing to do. Okay, so I shall stop screen sharing. for now. All right, we need to circle back to a couple of items that were on the rest of the jury charges. And I don't mind if it would be helpful to share this one as well. Was that helpful?
Very helpful. Thank you.
Is it the version that was sent last night? It should be, yes.
Yes, I haven't done anything to it. So I'm just going to scroll through unless anybody's thought of anything else to where we had noted we needed to. All right, the stipulations.
We're working on that as we speak.
Back up to the beginning and take out the counts on which a directed verdict was granted, which were counts 59, I don't know how to do that one. Laura, can you take that for action? Because I don't know how to get rid of the. Thank you. 59, 60, and 62 are out.
Yes, you're right.
And then
That's changing on both figures, is it?
63 is not gone completely, it's just different now.
Now it's a 131 instead of a 133,
Right.
correct?
Maybe we take off the language, previously convicted of a felony, we just say possession of a firearm by a convicted felon.
Right. Right, just ditch the previously convicted of a felony part. It would just be possession of a firearm by a convicted felon, 131. And we'll just have to explain to them something, I don't know what. All right, so then from Mr. Stillwell, 52 and 64 change. All right. Y'all are still working on the stipulations. And the stipulations, once you write them up, they can just go out with the jury? Or is that what they're going to do? I mean, in which case, if they're going out, I can just kind of generally say about these topics instead of reading them, or I can read them, whichever. So, I mean, normally it's like a piece of paper that's, you know, joint exhibit, whatever it is. I don't know if y'all have done any more joint exhibits, but
So maybe we just make reference to the joint exhibit numbers?
yeah. Okay. Have entered into, the parties have entered into stipulation about certain facts. And then,
I think there's 4 separate stipulations. So I don't know if it would make given each number.
these,
Is that correct, 4?
bad typing, but we can fix that later. These 4 stipulations will be are marked as joint exhibits. We can make it pretty later. Okay. Oh,
I say you might be an extra S in there.
really bad typing. Maybe I shouldn't type while it's on the screen. And then where the parties stipulate it's in the nature of evidence. All right. Apparently down on 13140, there was a question as to whether you were going to check, Ms. Hilton, on whether any of the criminal convictions were for a crime of dishonesty or making a false statement.
I don't think they are.
Okay, well, at this point, we're just going to say felony.
Yeah, they're not showing.
Okay. I don't know why this is highlighted.
Because I objected to it,
Okay.
but it's pattern, so I understand.
I've got a question. I mean, yes, a conspirator is an accomplice, but do we need to use both of those words here when we're saying where the witness is an accomplice? It wouldn't hurt to say or co-conspirator. Thoughts, anyone?
I have preference.
You don't care?
No, you
I mean, I guess we're going to tell them, here's how you can, okay, I'll just leave it the way it is if nobody has any preference.
Actually, I'm sorry, Your Honor. I think it's a good idea to put or co-conspirator in there. Just to prevent confusion as to about accomplice.
Anybody care whether we say on its own or by itself?
No.
We'll just go back, and I'm not going to do this right now, but we'll just say or co-conspirator for all of those. So I'll just highlight that, and we'll go back and do that. All right.
Your Honor?
Mm-hmm.
I could be mistaken, but the only concern with the accomplice or co-conspirator is that corroboration of an accomplice instruction. With it, if it's truly a co-conspirator, it's not
You're
that same
right.
legal principle. You know,
You're right.
I just don't, thank you, Your Honor.
All right. And we're instructing them separately about. Sorry. All right, and the defendants have both chosen not to testify, so we now know that. Any ideas? Coming back to here, y'all.
That's what I'm trying to figure out.
I think on the one above, we were trying to determine if that was appropriate, because did we really have a photo lineup type scenario where that would apply? I don't. And I think we were adding accomplices to the one below because we were trying to think through, there were no photo lineups type scenarios involving Mr. Kimball.
Yeah, there's no eyewitness identification really of either of these defendants.
However, there was
Well,
to certain overt acts
mhm.
that were not these gentlemen, specifically Mr. Demise McMullen, Mr. Walter Murphy in a shooting case.
Right.
I remember that, and there's probably others.
Okay.
So we were trying to figure out how, if you look at 135.
Well, yeah, and it's not even just lineups. I mean, it's like the girl who was in the car that identified Ryan as the one who killed.
And so I think that probably needs to stay in there. So I think in 135.11, what we were struggling with is it's written.
Yeah.
Defendants.
Yeah. Right. So,
Can we, I don't love the conspirator because it's almost, I know it's not intended this way, but it's almost like a suggestion that Ryan is a conspirator with us or Walter Murphy is a conspirator. Can we just say individual? Identify an individual? Rather than put a label on it?
Your Honor,
yeah.
the only, I'm thinking through in terms of, if it's not in regards to a defendant, the beyond a reasonable doubt, like the
Uh-huh.
germane issue of this is, how a jury's gonna
Right.
weigh a pretty
Yep.
significant identification of the
Yeah.
defendant in a crime.
Well, except that when we're dealing with the overt acts, even with Mr. Ryan, I mean, the overt acts still have to be proven beyond a reasonable doubt. So I don't think the standard is any different.
Now, this, I have no idea as the perpetrator of, I mean, it's not necessarily crimes that anybody's charged with if they're overt acts. As having committed,
The perpetrator of the act?
Yes.
and then not the party, right?
Correct.
Party. The perpetrator of or party to the act.
Or act/crime, whatever.
Well, act is broader. Then we
Ugh.
can slash crime.
Okay.
The act/crime?
So just
The
act.
act.
It doesn't matter.
Do y'all want this part at all?
Yes, please. If we have not.
That a defendant show
Is that the individual?
that
Okay.
another person committed any alleged offense. This part's weird because of our overt acts.
Should another person committed the alleged act? Perpetrated the alleged act?
That okay with the state? Just change offense to act?
Yes, Your Honor.
Okay. And then I guess we're fine with that. I mean, if we're going to say this part, I mean, I don't know that we need to say this part at all right now.
Or maybe prove the problem is, these are written for the quote-unquote defendant.
Yeah.
but Theoretically, we are, myself and Mr. Weinstein and our clients are essentially defending not only our clients, but other individuals as
Right.
well. But the burden of proof doesn't rest with us, so
Right.
it rests with the state. So I think that's an appropriate, I would just, maybe instead of, I would just go back to the more inclusive individual or.
But they don't have to prove a specific individual. I mean, they could prove some unindicted co-conspirator committed one of the overt acts. And so by definition, we might not know who they are. I mean, it says up here beyond a reasonable doubt. I think that's really all we need to, it's not necessary that the defendant show that another person committed the alleged act. I think the rest of this, because it's written for something that's totally not applicable here, maybe just is confusing and also not necessary. What do you think?
The state agrees that the remaining 2 paragraphs are not needed, Your Honor, for the purposes just outlined by the court.
But it seems that the last paragraph would apply when we're speaking about indicted or unindicted co-conspirators, but we have to change the language. Actually, I don't know what to do with that.
I do.
Could we add on the end of that paragraph that remains, like the burden of proving.
The burden never shifts to the defense.
Or the burden of proving identification, the state bears the burden of proof. Yes.
What?
That's what you do in the last paragraph.
The state has the burden or bears the burden of proving identification beyond a reasonable doubt. Well, we already have it beyond a reasonable doubt, but bears the burden of proving identification.
Say that. And then in the beyond
No.
reasonable doubt language.
How about just the burden of proof never shifts to the defense?
That sounds fine.
The state agrees, Your Honor.
All right. All right, I'm going to give that, so we're going to unhighlight that. Knowledge. So some of these come out. Yeah. I'm going to say a firearm here. Okay.
thought with the knowledge piece. Of course, the court outlines the crimes provided. The state just wanted to make sure and was thinking, out of an abundance of caution for the jury to understand that, RICO is not what, this paragraph is envisioning in terms of that knowledge requirement. I mean, the court or the state was thinking through out loud if, this specific provision or instruction, of knowledge doesn't fit the RICO instructions are kind of in their own universe.
Well, that's why it doesn't, I'm sorry. But you give a set list.
Yes, Your Honor, or this instruction is limited to these, counts or.
It sufficiently says this doesn't include RICO.
Thank you, Your Honor.
Okay, appreciate you bringing that up. Okay. All right, I'm saying this before the RICO also, but I don't think it hurts to say this one. Is this multiple ways of committing a crime only applicable to RICO?
No, Your Honor, I think when
All right, Laura, do you want to just delete all of the RICO stuff and drop what we just did into there?
Your Honor, in answer to your question about more than one way,
Mm-hmm.
that there are gang act charges here which allege more than
Okay.
one type of criminal street gang activity as the, I hate to use the term, but predicate or foundation for the criminal street gang violation. So we
Okay.
have that issue there too.
All right, so I'll just kind of say that in here in the midst of it, and then I'll say it again before I'm talking about RICO. Okay, criminal gang activity. Counts 50 and 57. This one may have to be separated out for each defendant. If we're listing crimes.
Well, we could put, I'm not.
Or we could
without
put-
looking at the statute, I don't know the term of art, but I think it's criminal gang activity. And
Yeah.
And then I think we could just put, the following offenses
Where did
would
it go?
constitute, if proven, would constitute criminal gang activity.
I have no idea where that,
But count 57 is pretty specific as to what are the actions.
I can't. What was somebody saying?
Well, you had the blank and it looked like you were looking, I was interpreting that as you were gonna add a specific offense. And I was thinking you would just put criminal gang activity as defined.
I mean,
And then we define criminal gang. It's defined, I think, above, but
it's not. Oh, yeah.
Your Honor, in that
Yeah.
paragraph where it has criminal gang activity, I believe there needs to be possession of either marijuana with intent to distribute, because it has any criminal offense that involves violence, possession of a weapon, or use of a weapon. So
Yeah.
there needs to be a comma, possession of marijuana with intent to distribute, because that's not defined in the first criminal gang activity. But it is
We don't have use of a weapon alleged, right? Oh, yes, we do. Never mind. Never mind.
You have it defined below, but not in the first criminal gang activity paragraph.
So possession of marijuana,
With intent to distribute.
does it have to be with? Okay.
That's the only charge left.
Does that capture all of it?
Yes, Your Honor.
So I think. Why is that
But
not highlighted?
I'm trying to understand, Your Honors, down here below where you have 50 and 57 lumped together.
Because that's subsection A. Subsection B, as a leader, or no, I'm sorry, to maintain or increase his status or position, which your client is not charged with.
No, but here's what I'm trying to understand,
Yeah.
and I need the court's help. In the indictment for count 57, if you look at that
Yes.
count, and again, I'm not really arguing, I'm just kind of hoping for some enlightenment.
Okay.
The street gang activity under A is, the offenses are specifically listed: possession of marijuana with intent to distribute, and then the codeine and the cocaine, which have been thrown out,
Right.
and then possession of firearm during commission of felony. So shouldn't, for a conviction under 57, one of those two things need to be found?
Yes, which is what the blanks would be.
Yeah, but that would apply to 57. Isn't it different for Mr. Stillwell in 51?
Yes. Yes.
Oh, I'm sorry. Okay. I
It's
understand
okay.
now.
I mean, so it may be that,
Or 50, I guess.
it may be that right here, we just say criminal street gang, or whatever it is, criminal gang activity. And then below, what typically happens then would be, can somebody look up never mind, I've got it right in front of me. No, it's 5.3 that lists what the gang activity is, right? Yes, Mr. Sharp.
So I would suggest we just put in criminal gang activity, and then we have the definition of criminal street gang, and below that, because we're just kind of going, I'm thinking sequentially by the elements. Below that, we define what you're about to talk about right now, criminal gang activity, and then we bring that paragraph that was just above all these elements, drop it down to there.
So you're saying move the criminal gang activity paragraph down?
Down, because it's like we're giving the definition before we give the elements. So we give the elements,
Okay.
and then we follow with the definitions that are needed.
Where in 1615.3 is anything about drugs? Is it just because it would also be an offense of racketeering activity?
Yes, Your Honor.
Okay. All right. Okay, so these would both say criminal gang activity, right? This is so painful. Oh, where's paste? And then take this and move it down below. Is that what you're saying? That makes so much more sense. Thank you. Commits a crime that constitutes criminal gang act. Well, I guess we'll do criminal street gang and then we'll do criminal gang activity. Right.
That criminal gang activity below. Because, we'll get there.
What?
I have a feeling, as we scroll down, we have criminal gang activity. Right, so we kind of said the same thing twice.
What are we doing?
Right where your cursor is, well,
Yes.
above malice murder, there's two paragraphs that right now are redundant.
This second paragraph begins to lead around as charged in this case.
This?
That and the paragraph above it both say the same thing in different ways.
Criminal gang activity means we don't have conspiracy to commit, right? Yes, we do. Sorry. Well, that's the definition, right? So what are y'all saying?
You're saying as charged in this case, and we kind of.
So, I mean, I think it needs, I don't think we need that, but murder, possession of marijuana, we don't have these anymore.
Okay. Your Honor,
Yes.
may I sit so I can see my screen? In count 57,
Yes.
and again, maybe I'm just not understanding this, maybe I'm just tired. In count 57, the criminal street gang activity is alleged to be based on the commission of one of
Possession of marijuana with intent to distribute and possession of a firearm.
right, so, but not murder.
Right, but
You have murder, but the problem is the way that it's worded with 50,
which is why we may need to separate this
with
one
57. That's what I'm trying to say is murder is not included in 57 gang activity.
out. I understand.
Okay,
but
thank
it's
you.
not going to be. They will have the language of each count when they do guilty or not guilty, and so when they get to count 57, the gang activity alleged against your client is not going to list murder. It's just going to list possession of marijuana with intent to distribute and possession of a firearm as alleged in certain counts.
Okay,
Okay.
as long as it's clear in that form,
Okay.
then I'll be okay with that, Your Honor.
58, 59, 60. Okay. So we're now we don't have to define this non-pattern charge because they're not being charged with it. Nor do we have to do possession of a machine gun. We do have to do possession of a firearm. 131, though. That is a pattern, right?
Well, Your Honor, machine gun is an overt act, so if we're.
Okay, well, why don't you just give me that again when you send all of the overt act things? Because I may actually. Okay, well, it's already in this or somewhere else? Right, but is it dropped into here anywhere yet? Okay, all right. Okay, we just need to pull the pattern for 131 then and put it in whatever that document is that Mr. Atkins sent. Okay, so does this say? Oh. It's just any felony, right? If it's 131? Okay. We might need to look at that whole thing again to make sure it's correct, but. All right. So possession of a machine gun. Laura, can you just lift that and put it in with the rest of those overt act explanations? Thank you. Possession of marijuana. We don't have that, right?
Correct. Well, that'll be.
We have it, possession with intent to distribute, right?
The marijuana, we do have it after the overt act.
Okay, well, that will need to go in where the overt acts are explained. So did y'all send that separately? Laura, will you just make sure that one gets grabbed also? We only have marijuana, right? No controlled substances now? Yes. I guess we'll still need this for some of the charges that exist, because, right? Yes.
Yes. Although, Your Honor,
Yeah.
could you scroll up?
Mm-hmm. More?
Well, if it's the over, I don't, in, on behalf of Mr. Pitt,
Yeah.
the state must prove the defendant possessed.
Oh, right, right.
The codeine and cocaine. Thank you.
Good eye.
And there it is again in the next paragraph.
Oh, see, now you're taking credit.
Oh, no, we're going to do a word search later.
It's also.
Yep.
That's what happens with cocaine.
It's everywhere.
It's everywhere.
Okay.
Right there, sir. In the sentence above, Your Honor, if you go back up to equal access, the second line.
Thanks. Okay. We still haven't gotten the verdict form, but mm-hmm.
The state did send a.
Oh, I'm sorry. Yes, I know. I mean, we haven't settled on one yet, nor have we reached a point of discussing beyond what we've, yeah.
I want to make sure.
No, yeah.
And I would really like some time to, I understand that you gave us a heads up on the verdict form, but I'm still going to need time to weigh in on that.
All right, so I think that's everything for this one, other than making sure of that. But now we need to go through, is everything patterned for the other crimes that are only other acts? No? Okay. Why don't we get out of this? And do you want this forwarded again to you so everybody can take a look at things that we might have missed?
Sure. Could we say it under a different title?
I mean, I guess we could do that. Yeah.
I didn't mean that sarcastically,
I know.
Your Honor, this is probably, of course, but the RICO that we worked on as well, instruction.
It's embedded.
Okay.
Yeah, it is in there now, thanks. Okay, let's see. All right, Laura, I'm just going to let you, are you going to be the one to share the, which would be easier? Okay, let's everybody take a minute. What's the date? November what? Thank you. So I'm going to title this November 20th, jury charges with RICO, and then Laura, you can send it. Whenever. They don't need that right now.
Well, we'll have to add all this in as well.
Okay. All right. And,
So I'm sharing this now.
okay.
So this is what the state sent over earlier. Obviously, I took the title off, but.
All right, so what's on the screen now is everything that would cover anything that's a crime in the overt acts.
Except there may be a couple we need to add again based
Okay.
on other things, but.
What is this called in the, is this in jury charges thing? What is it called? Okay. What a good title.
So, okay. You know what I'm saying? Mr. Weinstein just brought up a point to me.
Okay.
With these overt acts, the pattern charges refer to people as defendants, and I don't.
Yes, no, we definitely don't want to say that. So maybe we can just do a global replace of someone,
How
a
about-
conspirator,
How about actor?
Person. I definitely
Person?
a conspirator.
The
I think
person.
we
I
should
don't want.
comment on
I mean, okay, but maybe the person assaulted another person,
or
Actor.
the other person,
Actor.
the person, that's just going to get confusing.
Actor.
Perpetrator? Perpetrator. Okay, so do you know how to do a global replace? Okay.
or maybe
Alleged
alleged
perpetrator.
perpetrator. Yes.
Okay. All right, so we'll change defendant everywhere in there to alleged perpetrator. And then,
Can I ask, like, conspirator is not appropriate because you have to be either an indicted or unindicted conspirator to make everyone guilty. You can't just be some,
a conspirator, maybe?
yeah.
And alleged,
Alleged conspirator?
well, no, because they'd have to actually be a conspirator.
Right, but I'm concerned if Your Honor gives jury instructions saying the conspirator, that is not intentionally, but
No,
it's
but
a
might
kind
be
of-
saying, hey, they are conspirators, and
Right.
we don't want to do that. That's for them to decide.
I know that's fair.
Okay, so the perpetrator.
alleged perpetrator.
The alleged perpetrator, sorry. All right. All right, so there are 2 non-pattern charges. Criminal use of an article with an altered identification mark. Can y'all see that on the, I'm not the screen sharer right now, and Ms. Persfield's doing like 7 things at once.
There you go. That's where
Thank you.
I'll finish the rest of it.
Okay. So what are they alleged to have done, whoever had this? I mean, we want to get rid of the language that's not applicable.
Yes,
So,
Your Honor. It's just concealed.
conceals, when he conceals,
It's Act 53, Your Honor, in the indictment,
thanks.
which Trontavia Stevens, and then it goes on, criminal use of an article with altered ID by possessing a firearm from which the accused knew the identification mark had been removed for the purpose of concealing and destroying the identity of said article.
Oh, okay, so it's, a person commits the offense of whatever that is when he possesses, right? A firearm?
Yes, Your Honor.
I'm sorry, say that one more time.
Okay, so when he, and then get rid of from or all the way through possession, and then change it to possesses a firearm. Yep, which he knows. All right, and then that's it. Then I think it's fine.
You can take out nameplate, it's serial number, right?
We can, yeah. The manufacturers, what was alleged?
Serial number.
Okay. Serial number.
And we can try.
Or are there distinguishing?
And it said,
What it alleges is the identification mark,
correct, Your Honor.
which did y'all mean that to be the serial number?
I believe, Your Honor.
I think it's fine the way it is. Okay, and then implied, what is this? Why do we have that? Where did that come from? Number 10.
I include that in all my murder cases. McBurney gives it all the time.
Is that not in our,
Abandoned and malignant heart isn't defined. It's from, obviously it's a non-pattern charge, so I get.
I think we have malice in there, and we say malice can be, it is such, I'm paraphrasing, malice can be formed within an instant or something to that effect in a pattern. I think this is unnecessary because we already discussed malice in the pattern.
The pattern just doesn't define what an abandoned and malignant heart is. This says an abandoned malignant heart may be inferred from the circumstances.
Why do we need to
hang on,
define abandoned and malignant heart?
hang on, y'all. Let me get to the patterns. So it's,
For the reason that Mr. Bach just said.
for malice murder. Because the pattern says you may also find it when all the circumstances of the killing show an abandoned and malignant heart, which nobody knows what means, even though there have been case after case after case about what it means.
And maybe we don't need the first.
So,
We just need the abandoned and malignant heart sentence.
So, yeah, part of it's covered. We say you may also find malice where there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. So that first sentence is already covered. Oh, and the second, well, sort of the second sentence. So basically you're looking for a definition of abandoned and malignant heart.
Yeah, the first sentence I just put in there.
Okay.
Where it could be put in the pattern charge.
Is there any definition in the, like, bench notes of the pattern that define it? All right, I'm not going to do that. Delete that one. Is that everything? Those are all of the charges that are in the,
I just added possession of machine gun.
okay, well, all right.
It's out of the other set, but we'll go figure out how we're gonna do that.
Possession, oh.
And then I guess you're going to need to add the codeine and the
Possessed a machine gun.
cocaine back in if it's not there.
Wait, that's, they don't have to have possessed a machine gun during other crimes. They just have to have possessed a machine gun, and then we need to define what a machine gun is. I think we lifted the wrong one.
That's what we had in there.
Okay, well, we need to work on this one. That a perpetrator possessed a machine gun. A machine gun is any, yes, period. Yep. I think that covers it. Right?
And then, I don't know what happened to the codeine one, but we'll get that. The codeine
131, I don't know.
Codeine
and cocaine. Is there anything else?
We might need
Theft,
theft by receiving stolen property, because we have a few theft by receiving stolen gun charges.
those are overt acts that aren't, okay. Well, can you quickly grab the pattern for that? Is it theft by receiving stolen property?
Yes, ma'am.
All right. Is that a separate?
Can we go back? Can we go back to the machine gun when you get a moment, Your Honor?
Okay, yes. Theft by receiving stolen property is 2.64.80, which Laura, I can grab and drop in here, but will it show up on?
It should.
Okay. I'll just put it right there. Does that show up? Oh, well, you'd have to move it to that part. I put it right above possession of a machine gun. Is it there? Yeah. Okay.
Okay.
And obviously we'll need to change defendant again, but.
Can we go back to what you removed in machine gun when you have a moment, Your Honor?
I'm not the one moving it.
Oh, okay.
So yes, but we have to be patient with Ms. Persever.
I believe you removed language about commission of a crime. That's in the statute, and it's also the way.
On machine gun?
Yeah, it is. It's A1. It shall be.
What's the statute?
It is 1611-160.
Thank you. Have also never done a possession of a machine gun trial.
Well, there you go.
1611-150. Okay. 160.
On the machine gun? I will as soon as we get there. I have to get this added back in.
Oh, how interesting.
Yeah.
How odd.
I don't know why that is, but I'm not going to question the wisdom of our legislature today.
Okay, so it shall be unlawful for any person to possess a machine gun during, okay, so I guess we'll go back and lift them back.
And then in the count, there's a specific list of the offenses.
So it's only alleged that so that would be the two that are left, the possession, during the commission of possession of marijuana with intent. Are other people charged with possession of a machine gun?
Yeah.
All right.
There are. And so there's a list in 62, which probably should be included here, which is criminal street gang activity,
62.
possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine.
Possession of a machine gun.
I could read those off, Ms. Persenfeld, if you'd
Well,
like. Okay.
as it's indicted, it's participation, it's everything that's in 62. Is that what you just said? Okay.
Yes, everything in 62,
All
Your
right,
Honor.
so we can lift that from
Okay.
the indictment.
Thank
Or
you.
Laura can just type it right now. Okay, what else?
We'll need to add back in, Your Honor, possession of methamphetamine with intent to distribute, hydrocodone with intent to distribute,
Hang on just a second. Why are we adding those back in?
because those are Act 69 and Act 70, they're overt.
Overt
acts.
acts. So are there overt acts that are possession of a machine gun?
Yes, that is,
And those are 69 and 70?
no, I'm sorry. Possession of machine gun is 188.
So they were alleged to, Kitchens and Williams were alleged to have possessed meth and hydrocodone with intent to distribute at the time that that raid occurred?
No, sorry, two separate conversations, so I should finish.
Okay. So the machine gun one is fine now.
Yes.
And you're saying separately, as offenses that we explain, got you, we need to do possession of meth and possession of hydrocodone with intent to distribute.
And possession of MDMA, which is Act 77.
Okay.
Hang on, real quick. Which ones are intent to distribute and which ones are possession?
All of those are intended to distribute.
Methamphetamine, hydrocodone, and MDMA.
Those are all intent to distribute?
Yes.
Okay. And is there, other than the cocaine, is there anything that's just possession?
Do we,
No,
do we still have a simple possession of marijuana as an overt act?
I believe we do.
I don't know, and I know we're all speaking at once, but I don't know if you would need to do MDMA because it's Act 77 and it's just referencing what Mr. Nichols had been previously convicted of to make him guilty of possession of a firearm by a convicted felon. So we don't need that.
So we don't need that. Thank you.
Thank you.
So it's MDMA, no.
And the hydrocodone, no.
No, we need hydrocodone.
We do?
Yes.
We do, that's
Oh, sorry. Okay.
Act 70 for
Sorry.
And if we don't, I think we added it back, but possession of codeine with intent to distribute.
Yeah.
Yes. I'll go, try to go back for a double check.
Your Honor, I'm double checking. I'm just control Fing possession and the indictment to make sure I'm not missing
Okay.
anything. And there is Act 49 has possession, simple possession of oxycodone.
Okay, so on the possession, do you want them listed separately? I guess so, yeah.
All right, I think we're getting to the end, but I need a quick break because I didn't take one when y'all all did earlier. So I'll be back in a sec. Y'all can take a break too.
Thank you.
All right, while we were on the break, I think Ms. Pursfield caught a couple more charges that need to get included that were, I think, maybe drug charges as well. So we'll get those included. And then we will send out to everyone to take yet another look at these jury charges, including all the RICO we just did, the overt act crimes that we are just now including, and then hopefully everything edited correctly as to the rest of the charges. I think when we define the crimes that are just overt acts, they're not counts, that we need to set that off somehow, and I'll just kind of say, hey, you're going to get a list of alleged overt acts, and some of them are crimes. So I'm giving you the definition of those as well, something like that.
I think that makes sense, Your Honor.
Okay. All right, so I know the state has provided a jury form that they're going to try to further tailor now that we have a better concept of how we're charging. And I know that was tedious to get through, but I think it was very important that we did it, and it kind of took everybody thinking it through to get to there, so I appreciate that from everybody. And whatever y'all come up with in the way of proposed verdict forms, just forward to Ms. Pursfield. We'll look at all of that. I know y'all need to know when we're going to start the closings. The only things we need, and y'all still need to put those stipulations together. Just pointed out that there are certain overt acts that are alleged to also be an act of, a gang act violation. And we've defined those overt act crimes, and we have sort of defined what a gang act violation is, but when we did that, we only did it with regard to the crimes that were substantive counts of the indictment charges. And there may be there's like an aggravated assault or something like that, and other things. So
There's an attempted murder, there's a conspiracy for murder,
so we're going to need to,
drug sales.
I think to keep it clean, instead of trying to
still keep it separate.
Yeah, I think maybe we just
Okay.
do the same thing except criminal gang activity. However, we have
For purposes of this, the overt acts includes, okay.
Do you have to do that? And I'm just saying, I'm throwing it out because the catch-all says any act of violence, drugs, it lists like the categories. So I mean, an aggravated assault is clearly a violent crime. It's just a suggestion to make it less wordy, but
I agree with Mr. Biden.
Okay.
I think I do actually agree with Mr. Biden. I think that when we're defining, I don't understand the need. I wasn't going to die on that hill, but I don't understand the need to specifically say
These things
our
equate to.
criminal gang activity, and that applies to when we defined it earlier and now. I think we can just the problem is the definition of criminal gang activity in statute is very long, and then it has the catch-all, and then it becomes
Yeah.
and then you're making references to different statutes as well. Like certainly I understand the crime of violence, but then there's the catch-all, and then we would have to reference the RICO statute.
Mm-hmm. And that just gets to be a nightmare. And so when we are doing it for the overt acts, what are y'all saying? Or what are y'all saying that y'all agree to?
I liked what Mr. Abate said, but I also think it's going to get cumbersome if we expect them to parse through everything. But, so I would just do it the same way we did it in the first part and just say aggravated, what is it, aggravated battery? Aggravated assault would constitute, if proven, would constitute criminal gang activity.
That goes our first agreement.
Yeah.
And where do you want that?
Well, I think if we cut and paste from the
Yeah.
first part defining criminal gang or gang act, okay, and we put everything, we copied it and pasted it here as well for the charges for the overt acts, except when we have that little explanation of criminal gang activity, instead of putting murder and those other, we just put aggravated assault.
Can I make another suggestion? Your Honor, is your intention to charge on the overt act crimes first or second? Because my thought is, if we were going to charge on the counts first, you can maybe say criminal gang activity as previously defined, and then just put that last paragraph versus restating the entire charge, just saying criminal gang activity also includes this, and this, so that we don't have to say it twice. That may or may not be simpler, but I'm not sure.
Okay.
I think sorry, I'm interjecting, but I think the issue with that is the overt acts have to be with the RICO charges. Or we say something,
Yeah, I mean,
it could be later, but it has to be clear that these are related to, I mean, because because the overt act is mentioned in RICO, and so it either needs to get restructured or we somehow refer back to it, but it seems confusing if the overt acts are listed way after, totally away from all the RICO.
Maybe charges for overt acts and parentheses as alleged in count 1.
Or if you're doing the overt acts first, you don't have to repeat it the second time
I
when we're
kind of
talking
wasn't
about the
thinking
charge.
about doing the overt acts first.
I think my ultimate point was, I don't think we need
Yeah.
to repeat it twice. We can,
Right.
whichever time we do it, just refer back to.
All right, the gang counts against Mr. Kendrick and Stillwell are 50, 51, and 57, right? So what I could say is, after we define it, for purposes of counts 50, 51, and 57, murder, blah, blah, blah. Murder, possession of marijuana with intent to distribute, possession of a firearm during the commission of a felony constitute criminal gang activity. And then wherever we're doing it for the overt acts, say, for purposes of the overt acts, whatever they are, constitute criminal gang activity. Would that make sense?
Yes, but we have another problem.
Okay.
One of the overt acts is section D of the criminal gang charges. That would be number 182, unless that is out.
Oh, maybe it's out.
I think that's the leadership. It's out. Yay.
Is it out? I doubt it. Oh, excellent. Okay. I just mean excellent in that it's one less thing we have to deal with.
We said it too.
Okay. All right. Good catch, though, Ms. Persifield. So, thoughts as to whether I do the overt acts in the context of the gang, of the RICO count, or whether I just walk through, here are the definitions, here's how you prove the substantive crimes, the counts in this indictment alleged against these defendants, and then after that, hey, there are also some crimes that are within the overt acts, crimes alleged within the overt acts. Here's how those are defined.
Maybe some sort of transition, like as you see in the indictment, or as you'll see in the indictment, count 1, RICO refers to specific overt acts, some of which are alleged crimes, and then I'm providing these definitions in regards to the overt acts list, or something like that.
The question was, any preference as to whether that's done right after I explain RICO or after I explain all of the substantive count crimes?
No preference.
Yeah, I'm thinking right after RICO, Your Honor.
Okay.
It makes sense to just close that gap.
Okay.
But would you include these charges in the
I'd have to.
paperwork, or
Things
just
like-
tack them on at the end as an appendix? And then you could say, look,
No, all of everything I read is going to go out to them.
no, I want it to go out. I'm just wondering if the charges for the overt acts, if you embed it in the middle of the document right after the RICO section, or I think it may be more helpful to help them distinguish these from the acts in the count, is if you say, look in Appendix A,
Right.
and in Appendix A, you'll see how to understand the charges for the overt acts.
It's fine.
Is that okay with you?
Good idea. The state's nodding assent. Okay. Man, look at that. All right, so Ms. Pursfield, you noticed something else?
Yes, sorry.
Better now.
We don't have in the overt acts firearm possession, because there's a number of counts that are possession of a firearm by a felon. There's also a couple of counts that are possession of a firearm by a probationer. And then we have the charges against the inmates.
I'm doing that one. The probationer one is the same, is the pattern that you use for possession.
Yes, substitute probation.
So we'll add that, but then there's several possession of a weapon by an inmate, possession of a phone by an inmate.
I'm doing that one right now.
Okay, the conspiracy for possession by a phone by an inmate. And there's, I don't know if it's in or out, but the Ryan video while incarcerated.
Which number?
Is that a
That is
crime?
Act 180. Is that in or out?
It's in.
Right, okay, so I need something on that.
Well, is that a crime?
Right.
I don't know.
We didn't charge it as, we didn't charge the cell phone that he was using.
Okay, all right, but there are some possession of contraband by inmates.
Yeah.
charges,
Okay.
Or acts, alleged acts.
So, isn't, for instance, murder is alleged as an overt act, right? If I am defining all of the crimes that are overt acts first, within the context of RICO, I'm just afraid that I don't know what I'm afraid of. It seems worrisome to me, to some degree, that then that would be where they find the definition of things that they have to substantively consider against these defendants. You know what I'm saying?
Your Honor, my idea was if you use the appendix for crimes not otherwise defined.
Right. I agree with that.
But, okay, but
All right, but then the order of it, I just don't think,
I would say we would use I agree with Mr. Atkins, but I would think that we would do the appendix for the overacts last.
I agree. That's what I'm thinking.
Well, yeah,
too.
the appendix comes at the end, so
Right, but when we charge it, when I charge it, instead of saying, all right, now I've explained RICO to you, and now I'm going to tell you about the crimes that are overt acts. Here's how each of them is defined. I'm just going to say, I'm going to define those for you. If there are any, I'll just get to it later. And I'll do everything that's a count of the indictment. And then I'll say, you know, whatever I'm going to say. My brain's fried at this point.
yeah,
But
thank you. I'm just a beat
RICO
behind right
refers
now.
to certain overt acts, some of which are crimes. Some of them have already been defined for you. Others haven't. Here's the definition. Okay.
Okay.
Okay, what else?
So, so basically here under overt acts, this is in the RICO portion.
Doesn't it? I don't know. We'll figure it out tomorrow. You and I will figure it out tomorrow. Are you saying put that language there?
Well, that's what I'm wondering, is if this is in the RICO, I mean, not all of the
Yeah.
language, but a reference to where overt acts would be.
Well, can't you just put something in there to the effect of see Appendix A for definitions of,
Well, that's the question.
Okay, yeah. An overt act may, but does not have to be a crime in and of itself. That would be the place to say that. Some of the overt acts alleged in this indictment
are crimes?
are
Allegedly crimes?
well, some of the acts alleged in this indictment, if proven, would be criminal violations, would be crimes. If proven, would be crimes.
Yeah.
Are you?
Are you typing this or?
I'm not typing this. Nobody's typing this. I'll type it. Some of the acts,
Are you both typing into the same document?
We can.
would be crimes. Some of the overt acts, if proven, would be crimes. I'm just going to highlight that and think about that tomorrow in very Scarlett O'Hara fashion because my brain is not working anymore.
Helps, when you go through the indictment, the way we alleged it, where the overt act is a crime, we've identified the statute of violence. It's very easy.
Okay.
If you look at it, they'll know which ones.
Okay, great. I may even say that.
Of the overt acts, the
Those
subset
have
of those
a
that are
site.
crimes, those are clearly identified in the allegations, and they'll have that document. So they don't have to guess which is which. It'll say is a violation of the statute.
All right, I may just say something like those will have a cite to a criminal code section. Okay, so I'll think about that more and come up with some language. So,
Tomorrow is another day.
yeah, it may be tomorrow before that gets hashed out, but
We are working on a redacted indictment as well.
Okay.
So we'll get that tweaked and get that over to the court and everyone as well.
okay. All right. I think that we need to get together tomorrow and look at all kinds of things again, like hopefully a final jury charge, a jury verdict, what evidence is going to go out, the redacted indictment, all of those things. Which means that closings, which I think are going to take more than a day, don't y'all? I mean, if I mean, y'all said, I don't know, it seemed like the time periods y'all gave me. Once you think about the fact that people have to take bathroom breaks, that people have to eat lunch,
I rarely take a bathroom break, Your Honor.
that's 8.5 hours by y'all's estimates without any break. So that is more than a day's worth of closings. So I think that means we start closings on Friday, but we probably don't finish closings until Monday. And then I charge the jury, which I hope, I have no idea how long the charge is going to take, but I would think that the rest of the closing and the charge can be completed Monday. They get the case Tuesday.
Yeah.
Well, the end of the day Monday, but I mean, they're not going to do anything in that little amount of time unless I talk really fast while I'm charging. They have a short day on Wednesday. They have a short day on Tuesday also. Oh, wait. This is,
Maybe it won't take
oh,
them very long.
God, they do. These jurors, and I mean, they are trying to live their lives. I can't remember why we have a late start next Tuesday also.
Would you,
Saturday?
John, would you consider, I am very afraid of
Would I
closing on.
consider doing all of this after Thanksgiving?
No, that's not what I'm asking. No, that's not what I'm asking.
Because,
That's what the state's asking.
and only because, Your Honor, if we close and they take breaks, and say if we don't get a verdict back on Wednesday, you're going home, talking over the Thanksgiving dinner, and you're doing all of this, and you hope that they don't, but you don't know what
Well,
is
I'm
going.
instructing them not to, and whether they have gotten the case or not, they're not supposed to be doing that.
I agree.
And
I agree. But we would.
I'll get back to you.
We are.
Go ahead.
I think Mr. X told me not to say anything. I'm not.
Okay.
Matt?
Mr. Sharp.
This is my concern about Friday.
Okay.
State does their opening, closing on Friday morning.
Mm-hmm.
Myself and Mr. Weinstein close on Friday. Jury goes home for the weekend, come back Monday, and then all they hear.
It's like the only thing they hear is the states.
My proposal would be, I don't think everyone's gonna, I don't know this for a fact, I don't think everyone's gonna take as long as we think. I would ask if we could close on Monday, whatever we don't get done, I don't believe it would be much on Tuesday. And then we could give the jury instructions Tuesday, Wednesday, and then they could come back after the break to deliver. I just am very concerned about going for a weekend. And
Yeah, I mean, I agree. The other thing we can do is start the closings and have the state do their open close tomorrow afternoon. And then we finish with the closings on Friday. And then I instruct them on Monday. And they get the case on Monday.
I like the other idea better.
Hmm?
We like the other idea better.
Which was
Monday.
start the closings on Monday, finish them on Tuesday, which is a late start anyway of 11 at the earliest because of a medical appointment. And then I may or may not have a chance to instruct them on Tuesday, but I could instruct them on Wednesday, but then they have all of that, but then they don't actually start deliberating until they come back from Thanksgiving.
But they would have the written jury instructions.
It's true. They would have them in writing, Your Honor. It's not like they would
Well-
forget them over the Thanksgiving break.
Or we could,
Yeah, I mean, that's,
or Your Honor could instruct them when we get back.
No, it doesn't. They're not actually listening. I think people are more visual anyway. They're less likely to listen for 2 hours. The charge, that's the whole point of setting it.
I don't understand what you're saying, because,
When the court charges the jury, they're blank-faced. So that's why it's always so important to send it back like you suggested you do, because when anyone talks at you for more than 15 minutes, most people stop listening. So, not saying that they do. I know I do.
But it would seem to be in the state's interest to not have a 5-hour closing, Your Honor.
Easy.
Okay. Yeah, I like your idea for tomorrow, Your Honor, but I don't think the state, I guess the state would not agree to that.
they don't have to agree to it. I've
I
told
do.
y'all for the last 2 weeks, be ready on Thursday to give closings. So if that's what I decide, that's what happens when it comes down to it.
I'm just not looking to throw them under the bus, but I do like the idea for them starting tomorrow, and then we would wrap it all up Friday, or wrap up the closings Friday.
And you like that idea.
I do like that idea.
Only reason he likes that idea is because the jury charge won't be complete until tomorrow, and so he'll have all night to process and synthesize all the information that we'll continue to go over tomorrow.
Yeah.
Mr. Abate is not lying. It's my duty of candor. I have to tell you that.
I appreciate that, Mr. Weinstein, that you take your duty of candor seriously.
Very seriously, Your
All
Honor.
right, so closings Monday, maybe we finish Monday. If not, then we come in late on Tuesday and finish closings, and then maybe we'll just have to see. I charge them either Tuesday and they get the case, in which case I probably just won't. I mean, are they going to deliberate for one day and then go to Thanksgiving?
I would say we could probably close and charge on Monday after Thanksgiving, and then they'll have.
Wait.
We can certainly not close and charge in
I'm
one
sorry,
day.
not close. I meant
You
to
mean
say charge.
Tuesday?
Charge.
No,
On Tuesday?
On Tuesday.
but I think they should, if we charge them on Tuesday, I think they could begin deliberations immediately thereafter, correct? I don't think
Depending
they-
on what time it is.
We have court Wednesday, correct?
I mean, we're scheduled to have court on Wednesday.
What are the hours?
No, for the whole day.
Well, then that gives them a whole day to deliberate.
I
That-
had said, I had told Mr. Matthews we could quit at 2, but Mr. Matthews is no longer in this case. Have we told the jury that? I mean, the jury would,
I don't recall you telling the jury either way about the
Wednesday.
Thanksgiving. We had that conversation at the bench.
Yeah, I don't think I ever did, honestly. So I think they think they're here all day Wednesday. And so they could be here all day Wednesday.
What if when you send your message about coming Monday, know that we're gonna have extended hours on Monday. Wait, we start at 8:30 and we'll go till 7, so all the closings get done Monday.
And just get all of the arguments. We could do that.
Come on, first thing Tuesday, do the charge.
Well, at 11 a.m. or whenever they're all here, do the charge, get it.
You could extend Tuesday to 7 o'clock, since they're not getting here till 11. Or whatever time.
That's the state's suggestion, to keep them here till 7, just to make that clear.
I'm not staying here until 7 on 2 days, but. And then are you saying have them come deliberate on Wednesday and then take a long weekend and then,
Yes, Your Honor.
okay. All right. That's what we'll do.
Thank you, Your Honor.
Okay. So I still think we all need to get together tomorrow. How about 10?
Oh.
Unanimous agreement on
All right.
And there was much rejoicing.
All right. Thanks, everybody. Yes, I think so. We're going to have to get back together on jury charges and yeah.
Hey, Your Honor, they woke up Mr. Kendrick at 2 a.m. this morning. I know you don't have control over
In
the
order
sheriff's.
to get him here?
They moved him at 2 a.m. They woke him up at 2, moved him to Rice Street for whatever reason, then brought him here because I don't know all the thinking behind it, but come on. Can they please not do that? Especially we have a 10 o'clock start tomorrow. Certainly they don't need to wake him up at 2 a.m. again tonight.
I agree. I'm not the elected sheriff.
I understand that. I
Doubt if the
understand.
elected sheriff knows that either, frankly. But to my great and devoted deputies, can you all please get word to whomever is in charge of getting the defendants here to, if at all possible, not wake anybody at 2 a.m. to start transporting them for a 10 a.m. court hearing? Thank you. I really appreciate that.